thanks.
All right, it's loading up to stream. I'll let you know when it's all set.
Thanks.
All right, it's loading up to stream. It's always a second behind, but I think we're good now. All right, welcome everyone to the 2021 Feinrider competition. My name is Lena Abden, and I'm the Chief Justice of the Moot Court Society at NSU Law. And I am going to be thanking everyone here on this call for joining us on the YouTube stream, for joining us all weekend. Thank you so much to the judges who volunteered their weekend to come and judge our advocates. And congratulations to every single member who made it onto Moot Court Society. A special thank you goes to my board who worked tirelessly this year. This is, I think, our 4th competition that we've hosted online this year, and it's our last competition, so it's bittersweet, but I would love to thank Zoe Andriaszek. She is the mastermind behind all these competitions. George Dadal, who's the Justice of Academics, the Executive Justice of Academics. Marie Cadlick, who's the Executive Justice of Teams. And I would like to introduce our new board, our incoming board. We have Miss Kelly O'Neill, who will take my place as Chief Justice. We have Miss Gloria. She will be taking Marie's place as Executive Justice for Teams. Miss Lakshmi Apollinario, she'll be taking Zoe's position as Executive Justice of Competitions. And last but certainly not least, Mr. Jonathan Bornstein, he'll be taking George's place as Executive Justice of Academics. And with that being said, I know everyone is eager to see this this battle that's going to happen here. It's going to be intense. So I'll pass it on to Dean Juarez, who will give some opening remarks here today. Thank you so much.
Good afternoon, everyone. It's a real pleasure for me to be able to be here, and I know we are all looking forward to viewing this final round. It will indeed be very exciting to see. But I want to just take a moment to thank everyone who participated in making this final round possible. There's a lot of work that went on behind the scenes, and I want to thank in particular all of you who are involved with the Moot Court Society. I want to thank all of the faculty who teach in the Legal Research and Writing program, who inevitably behind the scenes participate in this. And I want to thank someone who's not able to join us today, and that is Professor Heather Baxter. She, I am confident, is absolutely with us in spirit, and I look forward to speaking with her about her views regarding this final round in the future. This is a really important competition, not just for the participants, but for the Moot Court Society and for the success of our advocacy program at Nova Southeastern University's Shepherd Broad College of Law. As many of you know, NSU Law moved up in the U.S. News and World Report rankings this year. We are now ranked number 36 among all 200 law schools in our advocacy program, and this competition and the Moot Court Society are critical parts of that stellar outcome. And so I want to thank everyone who makes all of that work possible. No pressure, but I am confident we are going to continue to move up thanks to the hard work that everyone is doing to make that possible. So I want to finally just note that we all love competitions, right? But this also has a very important educational purpose. And so for those of you who are not participating in this final round, but who participated in earlier rounds, I want to salute you and thank you for your participation, because I'm confident that you learned very important lawyering skills as you participated in this competition. So if you didn't make it to this final round, you still, in my book, are an absolute winner. And with that, I'm going to turn things back over to Zoe so that we can begin this final round.
Thank you, Dean Juarez, and thank you to all the judges who came out this weekend and spent your weekend with us. I know several of you spent several hours with us and many of our LRW students, and I especially want to thank Dean Duhart and Professor Baxter who helped me put on this entire competition, and my sidekick, Alyssa Letman, Lakshmi Apollinario, and Kelly O'Neill, who have helped me put this on. I would not be able to stand here alone and say that this is all me, because it definitely isn't. And with that being said, I would like to introduce our final panel. First up, we have Judge Melanie May. She is a renowned graduate of the Shepherd Broad College of Law. Judge Melanie May currently presides over the Florida's 4th District Court of Appeal. Judge May is a longtime member of the judiciary, even serving as Chief Judge of the 4th District Court of Appeal from 2011 to 2013. Next, we have Mr. Harold Pryor, a distinguished graduate of the Shepherd Broad College of Law. Mr. Harold Pryor was elected Broward State Attorney in November of 2020. He is the first Black state attorney in Broward and the first Black man to be elected state attorney in the entire state of Florida. Mr. Pryor leads a large staff of prosecutors in the 17th Judicial Circuit, working to ensure justice, equity, and fairness for those affected by the criminal justice system. And last but certainly not least is Miss Bethany Pander. She is a former Feinrider champion herself. Miss Bethany Pander graduated summa cum laude from NSU Law in 2018 as the valedictorian of her class. Ms. Pander is now an appellate associate in Greenberg Traurig Miami's office. She focuses her practice on appellate matters, commercial litigation, and trial support in state and federal courts. Now I'm going to introduce the two esteemed competitors who have made it to the final round, and that is Ms. Jordan Stein and Mr. Lexi Semino. Jordan Stein will be the plaintiff and Lexi Semino will be the deponent. And with that being said, I will pass it to our bailiff this round, and that is Ms. Kelly O'Neill.
Okay, competitors, please keep yourselves on mute until a judge indicates that it is your turn to argue. I'm going to announce in the chat the amount of time that you have left. Once each competitor begins speaking, your 10 minutes will begin. I will give you a warning when there's 5 minutes, 3 minutes, 2 minutes, 1 minute, and a stop when time is out. Judges, if you're ready to start, I'll begin with the opening remarks. Once I finish the opening remarks, I'm going to turn off my video and turn it over to the judges to call the case. The timer will begin as soon as the competitor starts speaking. Oyez, 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 all persons having business before the Honorable, the Eastern District of New York, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
You're on mute, Judge May.
I did hit the button. Good afternoon, everyone. We're here on the case of Osgood versus Shepherd Broadcasting Corporation. Is the plaintiff ready to proceed?
Yes, Your Honor.
Is the deponent's counsel ready to proceed?
Yes, Your Honor.
Very good. We're here on a motion to compel. Ms. Stein, you may proceed.
Thank you. Chief Justice May, Your Honors, and may it please the court. My name is Jordan Stein, and I represent the plaintiff, Mr. Bradley Osgood. Permitting a non-professional blogger to protect the confidentiality of their sources would weaken the sacred First Amendment reporter's privilege. Your Honors, the plaintiff respectfully asks that this court grant the motion to compel production for the following two reasons. First, the deponent does not have standing to assert the reporter's privilege under the First Amendment of the United States Constitution. And second, public policy does not support recognizing the deponent as a reporter for purposes of the First Amendment. In regard to the first point, standing, the deponent lacks standing to assert the privilege because the rule in this district is clear, and it is stated in Von Bulow by the Second Circuit, a 1987 opinion, that the person seeking to invoke the privilege has the burden to prove the following two elements. First, the intent to disseminate the information from the very inception of the news gathering process. And second, that the one seeking to invoke the privilege must show that they were engaged in traditional news gathering activities. As to the first element, intent must be shown from the very, very beginning of the news gathering process. The Second Circuit.
Would you concede that that Miss Maxwell did in fact have intent at some point to disseminate this information to the public? Or is your issue that she had no intent at all?
Yes, Your Honor, she did have intent, but that was after the fact. The deposition transcript shows on line 255 that the deponent only intended to disseminate the information to the public after she saw all the responses she received from already making him person of the week as a joke during Valentine's Day. The Second Circuit held in Von Bulow a 1987 opinion that the non-party was not able to assert the reporter's privilege because her initial intent was to establish credibility, and only afterwards did she intend to disseminate that information to the public. In the deposition transcript, lines 226 through 227 on page 5 show that the deponent's initial intent was to gather news solely to seek information about Mr. Osgood for her sister, who at the time was very unhappily married to him. The deponent even said herself that it occurred to her that a website could be a very useful tool as a way to help her get some information about Mr. Osgood. The deposition transcript also shows on lines 213 to 214 on page 5 that the deponent publishes information to get the attention from publishers and editors to get an actual job as a reporter.
Excuse me, Counselor, just briefly before you continue, I'm just curious, who carries the burden to prove this intent?
Your Honor, to prove the intent, it must be the deponent. The burden is on the deponent to show that they had the intent. And as to the second element, news gathering, the Third Circuit in Henry Madden, a 1998 opinion, noted that although Madden claims to be a journalist, hyperbolic self-proclamation will not suffice as proof that the individual is indeed a journalist. The court also noted that Madden never uncovered any story on his own. In the 10th Circuit in Silkwood v. Kerr McKee Court, a 1977 opinion, also held that the non-party was capable of asserting the privilege because he spent a considerable amount of time and effort in obtaining his information. But here, the deponent never uncovered a story of her own. She just passively accepted information and did no work of her own to go out and receive that information.
Ms. Stein, excuse me, don't you agree, though, that there's a trend now with technology to expand what is meant by reporter?
Yes, Your Honor, I would. As technology advances, it has definitely become more expanding on what things could be. However, the deponent does not fall into this category. She said on lines 154 through 155, page 4, and 168, page 4 of the transcript, that she does not take notes and that she purely relies on her memory. These are very traditional news gathering activities. The deponent—
Counselor, don't we view these traditional news gathering activities as non-dispositive? So it's not required that, a reporter or someone who's seeking reporter's privilege necessarily take notes. So can't her other activities qualify her for the reporter's privilege?
Yes, Your Honor. It is true indeed that just following case law, we have an idea of things that are traditional news gathering activities. Her not taking notes is a huge deal on top of the fact that she also doesn't meet the other requirements. And the deponent will argue that she doesn't need to engage in note taking because of the electronic means of communication that she has with her sources that can act as her notes. But when she first started Veritas, she made phone calls to verify her information. She did not use these electronic means. And her website was created in January 2020, and she posted Mr. Osgood in February 2020. That is not a big time. So there's a strong influence that she was not using these electronic means to communicate at the time, and she was purely relying on her memory from phone conversations about some of, if not all of the information about Mr. Osgood.
But excuse me, Counselor, didn't Roberta Maxwell, didn't she do research? I believe she conducted interviews. Isn't that a traditional reporting function?
That is, Your Honor. However, she did not fully conduct in that. She never really did interviews, and everything she did was very sporadic. She was never consistent, and she never engaged in constantly researching along with her editing process. She merely just strung together some messages and would edit out foul language, but never actually engaged in it. And therefore, we have demonstrated that the deponent was not engaged in news gathering activities. And even if she was, she never had the initial intent. As to the second issue, public
me.
policy.
Counselor, before you go on, in determining intent, is that a subjective or objective standard that we apply?
It is objective, Your Honor.
And do you have case law to support that?
Yes, Your Honor. The Second Circuit noted in Von Bulow, a 1987 opinion, that it is objective.
Thank you.
And public policy does not support recognizing the deponent as a reporter. And the compelled disclosure of the deponent's sources clearly outweighs the interest that the public or the deponent might have in protecting those sources. This is a case about reserving the right to cross-examine and confront a witness in a case. The Sixth Amendment is the right to confrontation. And although it only applies to trial, if this motion is not granted, then we will go to trial without Mr. Osgood ever being able to confront his accusers, which after all, is his Sixth Amendment right. And the First Amendment is not absolute. The framers' intent was to enact a qualified privilege for legitimate reporters. And here, she's not a reporter. The deponent started Veritas for the sole reason of finding gossip out about Mr. Osgood and hoping that a piece on him could maybe spark the attention of publishers or editors that could offer her a real job as a reporter.
Counselor, do you concede that if Ms. Maxwell would have written the exact same article with the exact same timing for publication in, say, a regular newspaper that's in circulation, that she would be entitled to reporter's privilege?
No, Your Honor. I think when it comes to the reporter's privilege, it shouldn't matter. And it doesn't matter if you're part of a big organization or if you're just a lonely pamphleteer, and the law supports that. However, it was the way she went about everything and her initial intent from the start of creating her website, which is why she cannot invoke the privilege. And giving the deponent the reporter's privilege would weaken the privilege because everyone would have to be a reporter and no one would ever have to give up their sources. This would be contrary to the fundamental principle of American jurisprudence that the public is entitled to every man's evidence as said by Von Bulow in the Second Circuit.
Counselor, shouldn't we use a balancing test to determine whether the privilege should be applied in this instance?
Yes, Your Honor, we could use a balancing test, but she would not meet it because, as you know, it is essential to find out who leaks this alleged scandal because it would help Mr. Osgood disprove SBC's allegation. Mr. Osgood was terminated because he violated the morals clause. So we need to get to the bottom of it. And the deponent did state in the deposition transcript on line 109 that employers do reach out to her to get information about particular media celebrities. So she did have bias. Your Honors, I notice that my time is expiring. May I briefly conclude?
Yes, please.
For the foregoing reasons, this court should grant Mr. Osgood's motion to compel production to prevent this unprofessional blogger from abusing and weakening the purpose of the First Amendment reporter's privilege. Thank you.
Thank you. Counsel for the deponent, Mr. Cimino, are you prepared?
I am, Your Honor.
Please proceed.
Chief Justice, Your Honors, and may it please the court. My name is Lexi Cimino, and I represent the deponent, Roberta Maxwell, in this case. We are before the court today on Bradley Osgood's motion to compel production from Ms. Maxwell, who was deposed in the plaintiff's action against the Shepherd Broadcasting Corporation. We respectfully request that the court deny the plaintiff's motion to compel for the following two reasons. First, Ms. Maxwell indeed has standing and qualifies to assert the journalist privilege. And second, as a matter of public policy, denying Ms. Maxwell access to the reporter's privilege would damage the American free press. To my first point, Ms. Maxwell indeed has standing and qualifies for an assertion of the journalist privilege because she engaged in investigative journalism and she had the sole intent to disseminate information to the public when she started gathering information about Mr. Osgood. The seminal
Counselor, if we were to apply the reporter's privilege in this instance, would we have to expand the law to do that? Or do you feel that your client fits within existing law?
No, Your Honor. It fits within existing law because the reporter's privilege is already necessarily wide. It's broad, and as opposing counsel mentioned, it not only embraces established news outlets, it embraces the lonely pamphleteer embodied by Ms. Maxwell. The lonely pamphleteer of yesterday is today's internet independent blogger, which is Mrs. Maxwell. And because of that, Ms. Maxwell is entitled to assert the journalist privilege. The seminal Second Circuit case of Von Buell lays out a 4-pronged test. The latter 2 prongs of that test are that a person attempting to assert the journalist privilege be engaged in investigative journalism that may not necessarily fit within traditional characterizations. Secondly, that they intend to disseminate information to the public from the very inception of their news gathering process.
And counsel, isn't that the heart of the issue here? That as plaintiff's counsel stated, Ms. Maxwell did not have that intent or form that intent until after she had already begun collecting the information. So doesn't that disqualify her from qualifying for reporter's privilege?
Not necessarily, Your Honor. It's important by looking at the deposition record to draw a strong, definite line of demarcation between private familial communications and Ms. Maxwell's gathering of information with a specific intent to disseminate that information to the public.
Excuse me, counselor, but couldn't it be argued that she never really intended to disseminate the information? It was really just to help her sister out? That's what I'm seeing here. Can you convince me otherwise?
Certainly, Your Honor. It's important to note that when Ms. Maxwell began to glean initial information about Mr. Osgood, based on page 6, lines 266 to 69 of the deposition, she shared all of that information directly with her sister because Veritas Media Leaks didn't exist yet. She had no avenue to disseminate that information to the public. As such, those were private communications between sister and sister. Once she established Veritas Media Leaks, she then named Mr. Osgood Person of the Week. And subsequent to that, she began to receive information from multiple sources, which she then verified by sending emails to multiple sources, multiple times, and corroborate that through extensive internet searching. The combination of those activities gave her the ingredients that she then utilized to comprise her public posts. As such, her intent to disseminate is more clearly illustrated by her actions rather than any words, because she established Veritas Media Leaks, then received information about Mr. Osgood from the public, and then edited that information and released it back to the public.
Is that reporting?
How do you respond to the plaintiff's argument that Ms. Maxwell does not engage in any substantive reporting activities, but that she's just passively collecting information from the public?
Your Honor, it is important to note that Ms. Maxwell has engaged in repetitive communication with her sources, as is evidenced by her deposition. On page 7, lines 316 through 320, she has not only emailed her sources repeatedly, but she has also verified the information through internet search. That a person attempting to engage in investigative journalism engage in a verifiable record-keeping process. In the case of Titan Sports Incorporated versus Turner Broadcasting System, a telephone commentator for a professional wrestling organization would repackage made-up gossip about wrestlers, but he would receive that gossip directly from the executives of that corporation. As such, that commentator did not engage in any sort of independent verification of those sources. This differs substantively from Ms. Maxwell because Ms. Maxwell directly communicated with each of those sources to make sure that she undergirds the information with the veracity of what multiple people are saying, corroborated by internet searches. Additionally, to opposing counsel's point about the idea that Ms. Maxwell did not engage in traditional physical note-taking, that is irrelevant because Ms. Maxwell has not only comprised an electronic transcript via her email records of every single source who she communicated with, she has a Flitter page. She has her own website with Veritas Media Leaks. This creates a chain of redundancy that would allow any person attempting to evaluate Ms. Maxwell's records with multiple electronic sources that Ms. Maxwell has preserved in a manner that is not likely to be breached or lost because there are independent redundant lines of electronic record keeping. Which brings me to my next point, that Ms. Maxwell had to have had the sole intent to disseminate information to the public when she started gathering information about Mr. Osgood. That is absolutely crucial because without that, she does not satisfy the fourth prong of the von Bulow test. In the case of Tripp versus Department of Defense, a reporter for an established newspaper interviewed a stranger, and that reporter's employment within the context of an established newspaper created a presumption not only that that reporter was engaged in investigative journalism, but also that that reporter had an intent to disseminate information to the public from the inception of her news gathering activities.
Excuse me, counsel. If we were to allow this privilege to extend to your client, how would we write an opinion drawing the line of where standing would exist for someone like your client?
Your Honor, the line to be drawn between where standing would exist versus where it wouldn't is simply based on the test laid out in the Second Circuit case of von Bulow versus von Bulow. That case lays out a definitive four-pronged test, which Ms. Maxwell has been able to satisfy in its entirety. As long as an independent person has an intent to disseminate information to the public from inception and is engaged in investigative journalism and satisfies the other two prongs of the von Bulow test, that person may assert the journalist privilege.
Counselor, isn't that problematic if we take such an expansive view on what you've argued qualify as the traditional, news gathering activities and later formation of intent to still allow to satisfy those elements? Would you argue that someone, say, someone who's going to take gossip and post it onto their Twitter feed or post it on TikTok in a 30-second TikTok reel, could they qualify for reporter's privilege if they, take notes and have a few emails to back up what they're saying?
Not necessarily, Your Honor. It is important to already read the expansive press privilege in favor of the deponent. In the Supreme Court case of Brandsburg versus Hayes, the court interpreted the press clause of the First Amendment to the Constitution as not only embracing the established press, but also embracing the lonely pamphleteer. Ms. Maxwell is today's lonely pamphleteer, which brings me to my final point, that as a matter of public policy, denying Ms. Maxwell access to the reporter's privilege would damage the American free press. In the case of Sines versus Yiannopoulos, a reporter for an extremist blogger's grudge mixed with journalistic intent at the inception of the news gathering process. This means that that blogger's legitimate journalistic intent was allowed permissibly to mix with a personal grudge that person held. The court found that irrelevant and still recognized that person as having journalist standing, although that person was denied journalist privilege later for unrelated.
So with that case on, thank you for putting that forward and alluding to Chief Justice's made point earlier. And given with the case that we have here at bar, how should this court weigh the plaintiff's right to a fair trial versus the respondent's interest in protecting their source?
Your Honor, I see that my time has concluded. May I please briefly answer your question?
Yes, please.
Your Honor, Ms. Maxwell's assertion of the journalist privilege does not in any way preclude the plaintiff from receiving a fair trial, because she is simply asserting a privilege given to her and that she is entitled to under the First Amendment of the United States Constitution. And that in no way infringes with the plaintiff's right to a fair trial. For those reasons, we respectfully request that this court deny the motion to compel. Thank you.
Thank you. Thank you both, counsel, for a very well argued issue. We will take this under advisement.
Congratulations to both of you. I think Zoe's going to move us to the deliberation room now. So we will be back.
Just gonna wait until all the judges are gone. Okay.
In the meantime, wow, what an excellent round.
That really was impressive. This is the first round I get to hear because I'm always in the back shuffling my papers and writing Post-it notes, but that was really, really amazing. And I've been hearing word of the two of you throughout the entire competition. So to actually listen to what you both had to say, I was blown away. Both of you are ready for a competition team.
Yeah, we're gonna, the tryouts are gonna be tomorrow, and then we're gonna put you on a team the following day.
Absolutely not.
No, really, you have no option. Right now, you are contracted because you're here. So you will be on a competition team, whether you like it or not. It's just a matter of which one. So without further ado, I'm going to list a few awards because I know there are certain people behind the YouTube screens that are waiting for the awards I am about to announce. Are we ready?
Oh, we're ready.
Okay. First up, I'm going to announce the best bailiff of the competition. Most of you do not know, but this was a 3-day competition slash oral arguments for LRW. So this was an extended competition, longer than we usually do it. So all the moot court members had to help us out for more rounds than they're used to, especially on Zoom, which is just exhausting. The screen time, terrible for your eyes, terrible for your skin, terrible for your hair, terrible in general.
Oh, the
So-
back. Let's not forget that one. That's a,
Oh, the back. The only thing it's great for is the bottom half of your body because you don't have to worry about what you're wearing. Okay, where was I? So the best bailiff, we have a tie between two people. This has never happened before in the moot court history of Best Bailiff Awards, which started 365 days ago. Okay, they are Stephanie Rodriguez and Mallory Sonenblum. So thank you for the two of you. The both of them deserve this award. Oftentimes between the schedules that I print out and that we send to each other and things change, people have to get removed from the schedule, and sometimes people get lost in the shuffle and don't show up to the rounds. And these two ladies showed up and filled in for several people who were unable to make it last minute. And I didn't even ask them to be on call. They just were on call. And for that, I'm extremely appreciative. I know what it's like to just already give up a portion of your weekend for moot court. So to really stand on call voluntarily means so much to me. Yes, Jordan, you may go get water very quickly. And Lexi, you may too. I know that right now you guys are probably both dying. I
feel like Johnny Perez deserves an honorable mention here.
Oh, I agree. You know what? We have a 3-way tie as of right now. We're going to add in Johnny Perez into that mix because he was always there too.
Oh, yeah.
3-way tie. There will be an award. Lena will get to you on that because we haven't decided the award yet, so can't get it to you. Anyways, the best Moody judge, another award that was very hard to choose from because we had so many great step-ins for the same reasons that we had the bailiffs. And this year's award goes to Mr. Zachary Stoner, always on call. He even travels in his car with his polo in case I call him, because he will flip on his judge switch and is in there in a second. So for that, Zachary Stoner, you deserve the award that is unnamed because again, we don't know it. And for the new Moody's that just made it on to moot court, and I'm talking to you, all the 1Ls that are sitting on your sofa and telling your parents, I did that. What they just did, I just did too. You should be very proud, even though you did not make it into this exact Zoom screen. You should be extremely proud because I know what it's like to be behind the screen and to have to do this and be nervous. My knees they didn't exist. I was just like this the whole time when I went. So I know that was difficult.
For those watching at home, I just have to emphasize, wow, what a competition this was. I mean, their hard work was so evident in every single round. And I think it's safe to say every single round was so close. Just all the 1L students worked so hard. So truly, we're so impressed and we are so proud of all of our new Moody's. We can't wait to have you.
And because we can't go without giving you guys things, we have sweaters that are for sale I was going to say you've probably seen them around law school, but you probably haven't because we've been on Zoom, the Zoom School of Law. But they will be for purchase. They are $35. They're very, very cute. I designed them myself, so they're very, very cute. As Kelly is showing, that is the front. Kelly, you want to show the back?
Yeah, we even got a little.
Very appropriate.
Very.
They thought of everything on that sweater. What can I say? So $35. We do have a limited number. So please email Kelly.
Yes.
Email
please
Kelly.
Tell me.
Email Kelly if you want a sweater. Just to save your sweater, I know that we maybe have one small left. More than anything, we do have a lot of larges. So if you want a large, you'll probably be able to get one. It's the small and the mediums that we are limited in number. And we may actually have one extra large left. So get your emails in if you want them. Save your sweaters. It's cold in that law school. It's cold in your house. Everyone should get some merch, is all I have to say.
It's cold in that law school and we'll be back this fall. So you
Yes, we
better
will.
bundle up.
Yes, we will. Do the competitors have anything they want to say? Do you want to thank anyone? We could pretend this is like your Oscar.
The Academy, your agents.
Anyone, your parents, me.
Okay, I could go. Lexi, you want to go first?
After you, please.
Okay. This is so funny. Okay, I would obviously like to thank my parents and a special shout out to two people. First, Jonathan Bornstein, because he's the whole reason I signed up. I wasn't going to do it. And then he helped me the entire way through. Every time I got nervous, so easily, like my number one shout out. Mallory Sonenblum was my mentor and she was amazing. She helped me so much. And then also a shout out to my friend George, who's in my section, because every time I got nervous and didn't think I was like doing enough, he would like give me the best advice to calm down. And that's it.
Lexi, do you want to go ahead and say whatever you need to say before the judges come back and give us your feedback?
I would briefly, once again, a big thanks to my entire family. I think they're watching this. And also to my Moody mentor, Alyssa Letman, and to all the other Moody's who helped me along the way, Jonathan Bornstein, also Lakshmi Apollinario. I don't want to take up too much time. I'm sorry, I see everybody's coming back. But thank you all. Thank you all. You all know who you are. You're all the best. I appreciate you.
So I think we're going to do some feedback first so that we can keep everyone waiting. And we just want to make sure that you sweat this out. So without further ado, I'll pass it back to the judges.
Okay, thank you. First, just on behalf of the judges, we want to tell you just how immensely we were impressed with your performances this afternoon. It's a delight to see young law students with this kind of professionalism so early in your law school career, let alone your future career. And we were all just really impressed with everything that you did. We're going to go around the three judges and comment, and then we'll come back at the end. I have the closing and we'll announce the winner. So Ms. Pander?
I echo all of Judge May's comments. Both of you did an excellent job and you should really be proud of yourself. I know that can sound cliche, but it's a lot of work to get to this point, and being able to represent in the final round is a really big, it's a great feather in your cap anyway. So congratulations to you both. I'll give you a few very brief little things I noticed during your arguments. Ms. Stein, I think you have great confidence that comes out immediately. You had an excellent command of the record, and your use of the deposition testimony in particular was very effective. One other point that I really liked was your ability to concede on certain points. So when we asked you questions, you were very comfortable, agreeing up to a certain point and then holding your ground. So that was effective to me. Mr. Cimino, again, congratulations on an excellent argument. I think you did a great job incorporating many cases. You didn't just stick to kind of the landmark decisions. You had specific cases from other circuits that you were able to effectively apply and bolster your argument. And I think that really strengthened your position. I also thought you had very strong organization, and it's clear that you knew which points you were going to hit, and you did a good job, even though you had a lot of questions from the panel, on weaving yourself back into that argument. And that's a skill that is difficult to master, and you're already well on your way. So congratulations to both of you. I'm very impressed.
Yes, congratulations to both of you. I really don't have much to add. Look, I'm not an appellate attorney. I am a trial attorney. I'm with the state attorney's office. I'm used to trying different things in a courtroom and having Judge May and her colleagues kick it back to my office. But I'll say this much: you two are talented. Ms. Stein, you came off as confident, cool, and collected. As a good friend of mine would always tell me, it seems like you sleep on the cool side of the pillow every night. You were really good and a talent. And Mr. Cimino, great command of the case law. I can't stress that enough. I think that's a skill that not many attorneys have who've been practicing for years, being able to correctly, right, point to case law adequately and correctly apply the facts to that case law. And it's just bobbing and weaving, weaving in and out with the case law and the facts. And I think you did a wonderful job of that. But I will say your opponent, Ms. Stein, she did a great job of just staying calm, cool, and collected, and also attacking those facts and also the case law as well. Great job, guys. You should be proud of yourselves, and it was truly an honor to judge this round.
Yes, I echo the sentiments of my colleagues on this tremendous performance. Just a couple of things that haven't been said. Both of you had wonderful introductions and gave us a roadmap for where you were going. Very, very important. I see that a lot in the competitions among schools. I don't always see that in first-year competition. So you had a lot of those polished moments that you see in performances of law students that are ahead of you in the number of years in law school. So you're to be complimented on that, as well as the people who mentored you to get that into your performance. That's a really important thing for those of us on the bench, so we know where you're going, just like you do in your writing, that you set out a roadmap and you follow it. And you were both excellent in that regard. Both of you had wonderful references to the record and to case law. I agree with those comments earlier. When you're on would be the appellee side, but in this case, your responding side, Mr. Cimino, I think it's a great thing to try and hit on points that the judges have asked the person who goes before you, Ms. Stein in this instance. And at first I started to write that would be a good thing for you to do. And then lo and behold, you did it. And you related back to something that she said. And so always, if you're in that second position, or if you're in the first position on rebuttal, that's really what you want to come back. What did the judges ask? And what can I say to convince them that my side is right on that point? And the last thing, I thought you both did extremely well, and I think Ms. Pander already mentioned this, which was the ability to not get flustered if our question wasn't going the way you wanted it to go, but to answer and almost concede what we've asked you, but then explain why that doesn't make any difference to your position in the case. Because I hate it when people fight you over the obvious, and they lose a lot of credibility that way. So that's also a very important lesson learned very early in your legal law school career. So congratulations to you both. And as we always say, we wish there could be a tie because you really were both that amazing, but we are directed to have a winner in this case. And so today, the winner of the moot court competition is Ms. Stein.
Thank you all so much. And Lexi, it was an honor. The NTA champion, final rounds of both.
Absolutely. Thank you everyone who watched, and thank you judges. Thank you, Dean Juarez. And this is our last Zoom competition. Hopefully next year it'll be in person. So